Hey everybody, Alan here, and this is going to be the first video in what I might call the Viewer's Choice series. Specifically following my appearance on Rich Rebuilds, I did a video asking what you guys wanted to hear about, what you guys wanted to talk about, and so I'm going to be doing my best to make those videos. One of the things that we talked about was, I called it Zen and the Art of High Performance Driving, or Guided Meditations for Motorsports. I think that's a really interesting idea, but filming that concept has really caused me to scratch my head a bit. If I can put something on that together, I think that'll be really cool, but I'm not certain that's going to be filmable, but time will tell. This first video, though, is a legal topic that a lot of people asked about, both in the comments to the original Rich video and in response to the Viewer's Choice video that I posted after that. And that is what the viability of the Chevron Doctrine is in administrative law as it relates to the EPA's ability to regulate following the Supreme Court decision in West Virginia versus EPA. And this is some heavy-duty administrative law stuff, which I am happy to talk about. A little bit of a departure from our usual automotive content, but I think it will all come back around at the end because, as a lot of folks suggested, this may have some bearing on the topic that Rich and I were discussing, which is specifically the ability of the EPA to regulate modified motor vehicles that were once street legal and emissions compliant. So this conversation really has to start with the federal Constitution. And I say the federal Constitution because, as I think people are innately aware but never consciously really thought about, the federal government and state governments in the United States are largely separate entities. We are the same country, but the governments are of separate creation and separate purpose, you might say. As it relates to the original colonies, the state governments are actually significantly older. Virginia's Supreme Court has been sitting since 1621, Massachusetts since something like 1647, but the current federal Constitution only dates to 1787. Now, what's interesting about that is you heard me say current Constitution. Not everyone realizes that this is actually our second federal government of the United States. The first, from 1776 to 1787, operated under something called the Articles of Confederation. Didn't work real well, and it was actually an attempt to revise the Articles of Confederation that led to the current Constitution that we have. Now, that document itself was revolutionary for its time. It is still fairly unique in the world, but at the time, it was unlike anything else on the planet, largely because of its sparsity. It is a very short document, it is a very brief document, and it is intentionally vague. The drafters were very much by design leaving a lot of the details to be sorted out over the ensuing years. So the document itself only states some of the what you might call the barest bones of what you needed to establish the government, and then the thinking was we'll flesh it out later. For today's conversation, we're going to talk about two of the three branches of government. As most people know, the federal government is three branches that are separate and equal: the legislative, the executive, and the judicial. Article 1 of the federal Constitution sets up the legislative branch, which is Congress. Article 2 discusses the executive branch, which is the president. And Article 3 addresses the judiciary branch, which is the Supreme Court, and, as the Constitution says, such inferior courts as Congress shall from time to time establish. The first two are more important for today's conversation because the Constitution gives specific powers and specific responsibilities to those various branches. And you have to understand that the framers were what we might call radical libertarians. They had just fought a war to overthrow a monarch, and they were not enamored with the idea of any one person having a significant amount of power. So the Constitution as it was written, now several of the amendments have changed this, but particularly the original text of the Constitution divided up power among several different people, branches, entities of the government, made elections somewhat complicated, and the whole idea behind that was that no one single person could assume outsized control over the governance. So one of these examples is with the military, powers are split. So the president is the commander in chief of the armed forces and responsible generally for national security, but Congress has the ability to declare war, and they have the responsibility for funding the armed services. So this is what we talk about, checks and balances. Each branch has the ability to check the power of the other or to balance out the influence of the other. I am setting that up because there is something called the Non-delegation Doctrine. And what that means is that each of those branches cannot delegate its core function to the other branch. And relative to our discussion today, one of the core functions of Congress is to write the laws, pass the laws, and enact what shall be the laws of the United States. Those necessarily involve policy choices, legislative decision making. Congress alone has that power. It cannot delegate it back to the executive branch. So let me give you an example on this. Most people are familiar with the Pure Food and Drug Act that was passed in the early 20th century. Congress made it a crime to sell tainted or adulterated or impure food and drink products. But it was left to the executive branch, the administration side, to set what is precisely allowed or not allowed. So I used to joke with my students 20 years ago, don't ever dive too deep into that if you ever want to eat processed food again. Because the FDA has tolerances for things like rodent feces and animal hair in a can of chili. I wish I were joking, but I'm not. Point being, whatever the parts per million or parts per billion that are allowable, that's allowable. What Congress can't do is say we're going to delegate to the Food and Drug Administration the ability to set all food-related crimes. No. That would be a violation of the non-delegation doctrine. But what they can do is say it shall be a crime to sell impure or adulterated processed foods, and we're going to let the Food and Drug Administration set what the specific guidelines are as it relates to the specific contaminants or pollutants. That's perfectly fine. And that has been the law of the land for over 100 years, I'm going to say. 18th and 19th century, we didn't really have the administrative agencies. That was largely a creation starting in the Great Depression, but really it was the 70s that we saw the rise of the administrative state. But perhaps that's another discussion for another day. What we're talking about here today is the Clean Air Act. As the Clean Air Act was passed, Congress said that they wished to regulate pollutants which presented a hazard to human health. And up until 2007, that did not include carbon dioxide. Carbon dioxide was not a pollutant for purposes of the Clean Air Act. It is viewed as one now, but for 30 plus years it was not. What we were talking about were things like sulfur dioxide, oxides of nitrogen, carbon monoxide, chemicals that all of us know are poisonous, toxic, hazardous to human health. So Congress said that they wanted to eliminate that from the air of the United States, but they were going to defer to the EPA to develop the specifics about that. And those specifics are embodied in something we call NAAQS, N-A-A-Q-S, National Ambient Air Quality Standards. And they were developed for each of these pollutants at a level that would not cause a hazard or a harm to human health. So how many parts per billion of sulfur dioxide? How many parts per billion of oxides of nitrogen, carbon monoxide, sulfur hexafluoride, all of these various gases that you can think of. And so the EPA would say, okay, we want the air quality standard to be, if a hazard to human health is at 50 parts per billion, we'll put a reasonable margin of safety on that. We want the air to be at 40 parts per billion. So we're going to allow 12 parts per billion per vehicle. This is all oversimplified, but that's how it was developed. Okay. Now, if one of these regulations is challenged, there is something called the Chevron Doctrine, and it deals with a reviewing federal court looking at a challenge. If someone challenges the EPA's authority, if someone challenges the EPA's rulemaking, the court first asks the question of, is there a clear delegation here? Is a congressional intent clearly stated? An executive or administrative agency can never deviate from explicit congressional instruction. So when Congress passes a law, that has to guide and that has to control the executive or administrative agency. And that agency can never diverge from a clear congressional instruction. But not all of Congress's enactments or not all of the topics are going to be so clearly stated. So if there's not a clear instruction, a court will defer to the EPA's interpretation of a statute so long as it is reasonable and not in conflict with some other provision of law. Now, this is what we talk about as something called minimum rationality. It's a type of due process review. Every action taken by the government or any branch of the government must be at a minimum rationally related to some legitimate government interest. No government agency in the United States can act arbitrarily. There is no arbitrary or capricious exercise of power tolerated as a matter of constitutional law in the United States. So it's a fairly low burden, but every action is subject to that type of review. So if the EPA develops a regulation, and the one we were talking about was about vehicles that were once compliant with the Clean Air Act and whether those can be changed. The courts are first going to look at, is there a clear congressional statement on this issue? I would argue no, there isn't. But then you say, okay, is this a reasonable interpretation and does it conflict with some other federal law? Well, you can argue it's not a reasonable interpretation, but this gets to the next topic that people were asking me about, and that is the West Virginia versus EPA case and something called the Major Policy Doctrine question, or the Major Policy Question Doctrine, I guess would be the better way of putting it. And that's an analog or a corollary to the non-delegation doctrine. And what the Supreme Court said, most clearly for the first time, really, this as a legal idea, this has only existed since about 2014. But the West Virginia versus EPA case was, I think, the first direct statement where the Supreme Court has used this specific language. And they said that in an issue that represents a major policy decision, the executive agency cannot undertake that on their own. The decider of policy in the United States is the legislature, which is Congress. And so any action by the federal government which would mandate a major change in policy must come from Congress. It cannot come from an executive agency like the EPA. So what happened here was people were challenging the EPA's ability to regulate electric utility plants, both as it related to existing air pollution under the Clean Air Act, which the court upheld actually, but also as it related to mandating different forms of generation. The EPA was trying to force utilities into shuttering their old combustion and fired generation plants and transition to wind, solar, etc. And the court said you can't do that because now you have entered into the realm of policy making, and only Congress can make policy. And to the extent this is relevant to our automotive conversation, I believe it is this. The regulation that we are talking about not modifying otherwise street legal motor vehicles, is a huge policy shift. The entire performance industry, the entire grassroots motorsport industry over the last 60 years has developed on the understanding that you could take a Clean Air Act compliant vehicle, remove it from street operation, and convert it to use in off-highway competition. For the EPA in 2015 to come out and say, no, you can't do that, that is a major policy shift. So while no one has, that I'm aware of, litigated this issue yet, I would agree with those of you that suggested that this would be a good argument to challenge the EPA's authority. Now, obviously, if Congress will pass the Recognizing the Protection of Motorsports Act, the RPM Act as we call it, then that would be a much simpler and much more direct solution, in that it doesn't have to go through the courts. You don't have the uncertainty of litigation, different results in different parts of the country, etc. You would have a clear congressional direction on the matter, and even under Chevron 1, that would trump anything the EPA did because you have a clear legislative statement. But failing that, could one make the challenge that the EPA's unilateral decision that once a compliant vehicle has been certified for compliance, it can never be altered? Yes, I do think that amounts to a major policy question, and in that sense, impermissible under the major policy question doctrine. So, comes with the disclaimer, though, as I said, that's just my thinking on the matter. At the moment, I am not aware of any federal court that has ruled on this yet. That EPA decision was only a few months ago. So it remains to be seen how the rest of the federal judiciary applies it. But certainly this is a developing topic and something to watch. So that's my thoughts for today. As to the automotive content, you see this beautiful 82 Jeep Scrambler, CJ8 Scrambler behind me. Probably do a video on it. It has just come in. It currently has a 305 Chevy in it with a new process 5-speed. And we're going to yank that 305. And let me get closer to the microphone. The heater just kicked on and it's really loud. But we're going to be yanking that 305 and putting in a GM high torque 383. So that's going to be exciting, I think. We'll do some videos on that build and hopefully one when it's finished. Not sure on the time span of that, though. The building that we're in was sold recently, and we have to move to a new location by the end of the year. Working on that, but obviously that's very disruptive to relocate the whole operation. But that's just another day in the life of a small business owner. So appreciate the feedback. Other topics you want to talk about, other questions, leave them in the comments. And see you next time.